Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to have to do it. We're going to have to talk about the pistol brace rule again, but this time, some pretty encouraging news. Now, we've already talked about the first lawsuit and the second lawsuit, but we're going to be focusing today on the third lawsuit because there's some really exciting things happening on this lawsuit, and you don't see this very often. So today, let's get you all up to speed on when Congress starts telling the ATF to pound sand. Okay, so the case we're talking about, and again, we have talked about it before on this video right here, is Firearms Responsibility Accountability Coalition v. Garland. That is filed in the United States District Court in North Dakota. Now, we've already talked about this case because there was some pretty exciting potential. Let us remember that there were 26 states that had joined the plaintiffs here in this particular lawsuit. Now, that was spearheaded by West Virginia Attorney General Patrick Morrisey, but he got 25 additional states to sign on. So at that point, we had more than half the states as named plaintiffs against the ATF on this new pistol brace rule. Well, to add to the excitement, and this is why I think this is, of all the three cases that we've talked about so far, major pieces of litigation to stop the pistol brace rule, why I think we're going to probably start focusing more and more on this case in North Dakota is because as of February 27th, 13 United States senators and 21 members of Congress have also filed with the court a request to participate as an amicus, which is a friend of the court, allow them to file additional briefs, and they too are joining in the motion to issue an immediate temporary injunction against implementation of the pistol brace rule. Now listen, I've had an opportunity to go through the pleadings. Of course, they're really, really well done, and we're beginning to see some of the same challenges here as we're seeing in some of the other things. But let us remember what the interest is here by these parties, because these parties are coming at it from a very unique perspective, which is, hey, you know what? Our job is to make the laws. See, we're members of Congress, and ATF is doing our jobs for us. And that's the angle in which this attack is being made, and it's a very unique attack. Take, for example, how they responded to their interest to this. This is how they put it. ATF's rule threatens the guarantee in a way that Congress never authorized. Article 1 of the Constitution vests all legislative powers in Congress. Federal agencies may exercise only that power that Congress has granted it, and Congress never granted ATF the authority to regulate pistol braces. And while we see a lot of different arguments ranging from the Second Amendment to the Fifth Amendment on constitutional takings, to the separation of powers, to the West Virginia case, to the APA, we're seeing a lot of different ways in which this pistol brace rule is being attacked. Plaintiffs here focus exclusively really on three challenges, all under the purview of the Second Amendment. In a very well articulated arguments, they state that one of the grounds they're challenging it is as follows. Indeed, the Second Amendment protects modern instruments that facilitate armed self-defense that are in common use today. Pistols with support braces readily meets those criteria. Millions of Americans rely on support braces to use their pistols safely and accurately for self-defense. ATF itself estimates between 3 and 7 million pistol braces are in circulation in the United States. And so you see how they are very correctly stating the common use test and how there is no way that ATF is ever going to be able to deem these weapons dangerous and unusual, which is the only type of weapons that we have a historical analog for regulating. As the plaintiffs put it in their pleadings, ATF cannot sidestep those protections simply by declaring pistol braces to be dangerous and unusual weapons. Attaching a support brace does not convert pistols into unprotected gangster-type weapons any more than attaching a rifle mount to a wheelchair turns the assistive device into a tank. Of course, they also point out that there is absolutely no historical analog available anywhere to support this type of restriction, or as they put it, to impose such restrictions after Bruin, the government must show that they are consistent with the nation's historical tradition of firearm regulations. But ATF made no attempt in its rulemaking to comply with that command, and such restrictions clearly would not pass muster if applied to other constitutional rights. They point out that, listen, maybe you need an executive agency to help define statutes if they're ambiguous, but there was nothing ambiguous about the definition of rifle or short-barreled rifle, as the plaintiffs put it. As the plaintiffs explain, however, the National Firearm Act and the Gun Control Act are not ambiguous, and they do not cover arm braces. And they went on to further state, Congress did not do so with the National Firearms Act and the Gun Control Act, so it is up to Congress to decide whether to amend these statutes to cover arm braces, not the ATF. In any arguments that the government may have that, well, this is ambiguous and therefore under the Chevron deference, we're allowed to come in and kind of regulate and interpret what all of this means, plaintiffs here very correctly point out that no. You see, when we're talking about felonies, when we're talking about people who are going to prison, the Chevron deference doesn't apply. It may apply to some regulatory scheme that deals with communications or the transportation of hazardous materials or things such like that. But when we're talking about placing individuals in prison, when we're talking about labeling them as felons and seizing their property, no, we do not use the Chevron deference. Rather, the rule is the rule of lenity. And it's important that we use that standard because we do not want executive agencies interpreting criminal laws. Why? Well, as the plaintiffs put it, the reason for applying this rule here are foundational. It preserves the separation of powers by maintaining the legislature as the creator of crimes rather than the ATF itself. And they went on to further state, and correctly so, interpreting the NFA and GCA narrowly because they impose criminal penalties corrects the encroachment on Congress's powers. And it particularly is important that the executive branch not be allowed to exercise legislative powers where, as here, it has tried to criminalize the exercise of rights enshrined in the Constitution. And then finally, they pull out the constitutional avoidance argument, which is an excellent argument. Without getting too deep into the woods, what it basically means is, hey, listen, if there's two interpretations of a regulation, one of which leads to all sorts of constitutional dilemmas and questions, and the other of which creates no dilemmas or questions, well, then courts should interpret it the latter way to avoid that entire dilemma. This is how the plaintiffs put it. Even if the ATF were entitled to Chevron deference, the doctrine of constitutional avoidance nullifies it. That doctrine provides that where a statute is susceptible to two constructions, by one of which grave and doubtful constitutional questions arise, and by the other which such questions are avoided, the court's duty is to adopt the latter. Okay, so once again, the case is Firearms Responsibility Accountability Coalition, FRAC v. Garland. It is filed in the United States District Court in North Dakota. We will put links for everything down below. This is a case that we are going to be carefully watching. Let us not forget now, this is a case that was brought by 26 states, which now we have over 40 members of the United States Congress joining in as amicus. This is the suit to watch. Listen, you may have more questions about this suit, the pistol brace rule, or anything else related to what's left of our Second Amendment rights. And you guys should know the drill by now. You could always contact us at WashingtonGunLaw.com, or you can call us at 425-765-0487. In the meantime, let's remember, part of being a lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.